Now like to introduce our Mayor, the Mayor of Moreland, Lambross Tapanos, and Lambross will share his thoughts on the upcoming legal challenge and the strategic importance of local government in taking a stand on these sorts of issues. So,
thank you.
Lambross.
Thank you. Okay, I was hoping we would have a lectern because I have a bit of a speech, but I might dispense with it and just speak off the cuff and refer to it briefly. But can I begin by also acknowledging the traditional owners of the land we are on, the Wurundjeri people, and pay my respects to their elders past and present, and welcome everyone here this evening to this really good and important forum that we are having about the East-West Link, and I'm glad that it is taking place in the council facility, this brand new hall, this converted hall, which is open for the community and can be booked online if anyone wants to use it. Bit of a plug there. Okay, well, I want to start by telling a story. I guess it's a story that began, particularly for Moreland City Council, began back in July, and that's the story of this court case. A story that hasn't concluded yet and will conclude on the 15th of December. And we hope that it will conclude in a favourable way and it would actually change the course of Victoria towards a future that's not relying on vehicles, but a future that's relying on public transport and a holistic approach to moving people. And all of you here are part of that story as well. I must acknowledge as well the community campaign that has been run has been quite significant, and that should not be underplayed at all. The support that the community has provided to this campaign is instrumental in changing public opinion, and well done to everyone who's been a part of that as well. But I'll take you back to Thursday, the 17th of July. It's a quiet day in the office. I don't think it's been that quiet ever since, to be honest. The CEO came into my office and he had said that he had been speaking to the lawyers that had been running the case for Yarra at the assessment panel. And Yarra was probably not interested in appealing the case any further and seeking a review. And Darebin and Moonee Valley, for their own reasons, probably couldn't have. And it was up to Moreland, and we had 21 days, which coincidentally sort of expired the following Monday, and we had to launch an appeal if that was to be the case. And it was a tough decision, and it was a decision that we didn't take lightly. And I sat there for a few hours pondering whether we should proceed or not. And I thought that Moreland has always been a council that has represented the community and hasn't been afraid to make hard decisions in the interests of the community. Moreland has always been a council that says, no, we are going to put our money where our mouth is and we are going to take issues serious. It's not just about running the campaign, but it is about taking all possible means to stop the project. And that means also taking legal action. And we knew it was going to be a tough decision. We knew that we have many planning applications at Minister Guy's office. Many of those have since been rejected. We knew that people would come after us, and they did. We knew the state would come after us, and they did, with some colourful language, odd bods and crazies, which I thought was kind of interesting. And I also thought that when you resort to personal attacks, you've kind of lost the merits of the argument anyway. We knew that certain friends in our media will come after us, and I should acknowledge the Herald Sun. They've done a great job. You know, and also one of their journalists here, Tom as well, welcome. I know Tom works very hard because he's attempted to interview me at 6 o'clock one morning, but he went to my parents' house instead. But Tom, just letting you know, Tom, my phone number is online on the internet and you can call me whenever you like. So, yes, I should probably get to the substance of what we're here to talk about. So we organised a special council meeting, and on the following day, on Friday the 18th, we sat in a special council meeting and we determined that it was critical to proceed with seeking a judicial review. Now, for those of you who don't know, a judicial review is a very important part of our legal system. It's a very important part of the checks and balances in our legal system, and it says that a party that is affected by a government decision has the ability and has the right, the legal right, the common law legal right to seek a review of that decision in the courts. And we participated in a process, the assessment panel process that was spoken about earlier, and we put our positions forward about the impacts on our city, about what the East-West Link will do to recreational land, particularly Holbrook Reserve and the loss of trees and the loss of recreational space, what it would do for noise levels, particularly around Brunswick West, what the future potential impact will be on the Tulla Freeway and whether that will need to be expanded into the future, the impact it would have on the Upfield line, particularly during the implementation, and also on the city bicycle trail, particularly during the implementation. And we said that all of these were our concern. And yet, despite the fact that we had some positive recommendations on these issues from the assessment committee, none of those were really considered by the minister in approving the planning permits for the East-West Link. And we were very disappointed with that. We were very disappointed that we had participated in a process and we thought that the process did not give us natural justice. The process did not lead to outcomes that our community desired to see and our council had fought for. And the process, we think, and particularly because we weren't given access to a business case, was flawed, was fundamentally flawed. And certain points of law were not taken into account. And on these grounds, we decided to appeal. Now, it's important to note that the assessment committee and the minister were obliged under the decision-making principles under the Transport Integration Act 2010. And this provision of the Act includes doing a triple bottom line analysis of the impacts of any project. So that is a social, economic and environmental assessment. And we don't believe that the panel in its recommendation or in the minister in his decision took any of that into consideration. And we've already heard the minister say that he made a decision based generally about the economics of the project, not based on a business case. And we say, well, that's not good enough. You are obliged under law to take a business case into consideration. And whether he has or he hasn't, whether he had access to it or not, is something we hope will come out during the court process. But we also acknowledge that we should have had access to it, because without it, it is difficult for Moreland to put its position forward about the impact in Moreland City Council. And I'll give you just one example. We are very concerned about the impacts of local traffic, congestion on our roads, our local roads, particularly Brunswick Road, that is already very busy. Now, what we don't know is what the toll will be. And of course, if it's a very low toll, it might encourage more people to use the road, and we might see more vehicle movements within our city. However, if it's a very high toll, we would actually see less people using the East-West Link, but we would see more rat running throughout our city. We'll see more people getting out at Brunswick Road and going right through our suburban streets to avoid the tolls. So it's a lose-lose in that sense, but we are not able to determine the outcome without knowing what the toll will be. And we're not able to do modelling about how it would impact our city if we don't know what the toll will be. And this is all in the secret business case. So without this information, we were disadvantaged in putting our position forward. But also, this is not just about a particular road, even though it's such a significant and expensive road. This is also about openness and accountability in governments. The fact that a government believes that it could sign contracts worth billions of dollars without going through a proper process and seek to exempt itself from a judicial review, a fundamental part of our legal system, is just wrong. And we say, particularly at this point in time, a few months out of a state election, allow the Victorian people to actually have a say on this. If the project could stand on its own 2 feet, it should have been allowed to be decided upon in the election. If the business case showed that there was an economic benefit to Victoria and solved a lot of the congestion problems, the business case would have been released, and the government would not have feared to seek to release that and have its actions scrutinised by the courts. So these are the fundamental issues. We are in court, and we have been in court quite regularly over the last couple of weeks, and we are seeking what we call, or what the courts might call, a discovery of documents. And this was something that the government initially tried to stop But we've been very successful, and the court has ruled in our favour and has determined that the minister now must provide to the court a list of all documents that were in his possessions or considered during the decision-making process. Then we had another battle with the government in regards to when would this be dated to. They were clearly seeking a shorter date. In mid-2014, we were seeking to go back to the start of 2013. And the court ruled, I would say, generally in council's favour, and we have a date of October 2013. So all of those documents going back to that date will have to be provided. And we hope this means that we will get access to the much secretive business case that everyone's been talking about. And we'll hope that it will be able to be released as part of our legal challenge. So let me just go through some of the notes. I've spoken about a lot of stuff already. The impacts are not just around Moreland City Council, but there is also a huge economic impact in the sense that if such large sums of money are spent on the East-West Link, then that is money clearly that is not available to be spent on a whole range of other projects. And I'm holding this document here this evening, and this is our plan for urban renewal and grade separation along our sort of major crossings and fixing our crossings and removing them. And this is actually a plan, I don't want to go too much off topic, but this is a plan we developed with Darebin City Council to remove 8 grade separation projects. It is a plan that we believe will offer more economic benefit, would take more congestion off the roads and would lead to much greater benefits if such a program was implemented right across Victoria than what the East-West Link ever will do. So we've been lobbying for a whole range of public transport improvements, a whole range of programs just like this one, and we haven't been able to get very far. In fact, we've seen this state government in particular cut a couple of bus routes from our city and not invest in any public transport programs. So we are saying the priorities are wrong. We want to see money spent in public transport, and we know that every dollar that is spent on this East-West Link is a dollar not spent on other projects that would deliver a greater benefit. And those projects go right across Victoria. Every municipality has local projects that they want to see done, but they're not getting very far because all the money will be taken up on this project. So those are the major reasons. We are in court, as I mentioned, on the 15th of December. We've had significant wins as far as the discovery of documents already. And I'm pleased to say from a money perspective, and there's been a lot of talk about how much this is actually costing ratepayers, that process to date around the discovery of documents, the court has ruled in favour of the council and is awarded costs to the council, which means the state government will be paying the council's legal costs to that point. So that's been a big win there. But as I said, we spend a lot of money coming up with strategic documents like this and a whole range of money lobbying the state government on behalf of our community for public transport programs. And we're seeing this challenge as a small investment, this challenge which would potentially cost us, combined with Yarra City Council, around $350,000 if we're unsuccessful, or if we are successful, it could be as small as about $120,000 or $130,000. That's only a small sum of money compared to what this East-West Link will cost Victorians in the future, and it's a small investment to be able to get the state government's priorities right in the future and fund essential public transport initiatives in our city and right across Victoria. So where to from here? There are 2 major things that need to occur. Firstly, it is a referendum in November on the East-West Link. We do need a change of government. If we don't have a change of government, then any legal action won by Moreland and Yarra on the 15th of December will only simply delay the project. The state government could put legislation through the Parliament to enable the project to occur, and of course they can remedy and fix any oversights that they did, or any errors that they did in the approval process to date. So if we don't have a state government, a change of state government, we will end up with the East-West Link. That's very clear. So we need a change of government, and we also need a win in the courts. Now, even if even if a Labor government in the future does not challenge or does not defend the action in courts, a judge would still need to rule in favour of Moreland and Yarra, and that's an important point to make. It's not a done deal. There would still, the merits, the legal points would still be considered by a judge. But we are very confident in our legal team, and we are very confident that we sit on solid grounds and we are going to win this case. But that process needs to occur in the courts. So the message is now loud and clear. The Victorian public will get their say, and then we will have our day in court. And if we have a win in both those two battles, what that would mean is that despite the fact there is a contract signed, and I'd like to speak a little bit about that as well, there is no project. There are no planning permit approvals. And if there's no planning permit approvals, if the court squashes the planning permit approvals, then really you don't have a contract. And that's an important point to make, and that's the point Daniel Andrews is making, and has received very high-level legal advice that basically says the contracts are really not worth the paper they are written on. And I wanted to talk, I spoke a little bit about, how long do I have actually? Give me 1 more minute. I did want to speak a little bit about the role of governments, and at Moreland we also undertake some big projects, and we've got some big projects occurring just across the road in central Coburg. And dealing with developers is always tricky, and I won't name any of the ones we discussed, but I want to put this example as a case where we're doing major urban renewal projects. And just before my time in early 2008, it was a time to sign a contract with these developers, effectively, to design and develop this project. And the council said very loudly and clear, you are dealing with a local government authority. A local government authority that's just about to go into an election. You must provide an out clause. And we've heard of this $500 million out clause that has been suggested in this case. Well, what a lot of rubbish that is. Back in my Moreland example, of course the developer comes and says, we would punish the community if they elect councillors who won't proceed with this project. In the same way, the developers are asking the government to sign a contract that will punish the Victorian people if they don't re-elect a coalition government. And we've seen this figure, and I don't know where this figure has come from. But certainly in normal legal contracts, out clauses do exist, and they should represent a fair and balanced sum, which is the work done to date by the contractors or by the companies contracted to do the work. Now, you can't tell me that 2 months' worth of work is worth $500 million. This should never have been agreed upon. We don't know if it has or if it hasn't, to be honest, because we haven't seen the contracts, which is another problem. But a good state government would say, no, we're not accepting that on behalf of the Victorian people. We want an out clause that you take the burden on, because you know you were dealing with a state government that is just before an election. Don't punish the Victorian people. Put an out clause in there that is fair and represents the cost to you over the period of 2 months. So you just wonder, a state government that negotiates with a big developer and has an election, a looming election, and is seeking to sign contracts at all costs, and now they have been signed, are they really signing contracts and negotiating in the best interest of the Victorian taxpayer, or is it really the political interests of Dennis Napthine? Are they really being taken advantage of by the developer who's out to make as much money as possible? And this is really something that should be of concern to all Victorians. And also, leading up to an election, now that it is a referendum, what interests are at play and how much money is potentially going to be spent by these people who have these interests in campaigning to re-elect a coalition government to proceed with the project. I think that this should be concerning for everyone, particularly should be concerning to our democracy. So these are major concerns we have, but I'm very hopeful that we will get a change of government and a win in the courts and be able to stop this project. I think I've taken enough of your time. Thank you.